Welcome to the Mulcahy Law Firm podcast. For over 25 years, Mulcahy Law Firm has helped plan communities and condominium associations throughout the state of Arizona. Please go to iTunes or your favorite podcasting platform and leave us a rating and a review. Thank you for listening. Here's Beth Mulcahy.
Good morning, everybody, and welcome to our 2023 virtual HOA Condo Academy. We're having our 11th class this morning on successful associations and qualities of an A-plus board member. Good morning, everybody. As you're joining, I know we've got a number of people joining us on Zoom and Facebook Live this morning. Welcome to class number 11, 2023 virtual HOA Condo Academy, which our firm teaches in partnership with the cities of Avondale, Chandler, Glendale, Goodyear, Mesa, Peoria, Phoenix, Scottsdale, Surprise, and Tempe. This month, I am also celebrating 27 years of legal representation of associations in Arizona. I'd like to do a special shout out for all of our clients and friends in the HOA industry who I've known for the past 27 years. It's been a lot of fun working with associations, and I look forward to 27 more, hopefully. Let's start out by just doing some quick introductions. For those of you who haven't joined us before on one of these neighborhood services HOA Academy classes, my name is Beth Mulcahy, and I'm the managing partner and senior attorney of the Mulcahy Law Firm in Phoenix, Arizona. I have enjoyed representing HOAs and condominiums for the past 27 years, and my firm currently represents over 1,000 planned communities and condominium associations throughout the state of Arizona. I also currently serve on my HOA board, and I have for many years. Before we dive into the meat of the seminar today, I'd like to start off by getting a feel for who's in our audience today so I can best tailor my class to fit the audience. We're going to be launching 2 polls right now on Zoom, and if you're joining us on Facebook Live, please feel free to answer the question in the comment section on Facebook Live. And there's 2 questions. The first one is, which city do you reside in, or which city do you own property in an association in? The second question is, let us know what your current role is with your association. Are you a board member? Are you a community manager? Are you an interested homeowner who's not a board member? Or do you fall into a different other category? Okay, while we're waiting for the poll results to be distributed, we're going to talk a little bit about what's on our agenda for today. In today's class, I'm going to be providing first a summary of the HOA and condo bills that were signed into law this legislative session in Arizona. Remember that Arizona has a seasonal legislature, and so the legislature closed. It was one of the longest sessions this year, actually, in 2023, but it ended in late summer, early fall, and all of the new legislation went into effect on October 30th. And there's 5 new laws that pertain to associations in Arizona and condos and planned communities in Arizona. And we're going to be doing a quick overview of that this morning, just as a reminder about the new laws, and also we'll be giving you a cheat sheet on a deep dive on the new laws. And then we're going to move over and look at what are the secrets, or what's the secret recipe to have a successful association. And like I said earlier, we work with over 1,000 associations in Arizona. I have been seeing different types of associations and working with different associations for a quarter of a century plus. And I think I can pinpoint pretty directly what are the characteristics to have a successful association. So this will be a great part of the presentation to give you some tips on how you can get to being a successful association if your association is currently struggling right now. And next, we're going to talk about how to be an A-plus board member and what are some of the do's and don'ts if you're currently serving on your board. And lastly, we're going to finish up with internal conflict on your board, what to do if your board members are not getting along or fighting, and it's prohibiting you from getting your work done for your community as a board member. So we have a pretty full class today, and really happy to have everybody here with us. At the end of the class, what we're going to do is have a question and answer, just like we always do. And we encourage you to submit your questions via the Q&A box on Zoom or in the comments section of Facebook Live. And we will answer every question today during this session so that you feel that if any questions come up, that you have had your questions answered as part of this class today. Reminder, please limit your question to 1 question per person. And please be specific and clear in your question because it's really difficult for me to follow up with you live as I'm teaching the class. So try to really think about the question that you want to ask and make sure that it's very clear so that I can answer your specific question. Okay, let's go back and see the answers to our poll question. So we have, wow, this is great news. We've only had this, I think, maybe one other time this year. We have every city in the Valley that we are teaching these classes for represented here today. So we have 2% Avondale, 9% Chandler, 2% Glendale, 9% Goodyear, 15% Mesa. Great job, Mesa. 6% Peoria, 25% Phoenix, 20% Scottsdale, 3% Surprise, and 9% Tempe. So we have a really great representation of both the East and West Valley in Arizona and Phoenix metropolitan area today. So happy to have all of you joining us here today. Now let's switch gears and talk about what's your role with the association for those of you who are here today. It looks like we have over 100 people, 104 people joining us on Zoom, and probably 20 or so more joining us on Facebook Live. Of those of you who responded to the poll, 75% of you that are joining us here today are board members, 8% are community managers, and 15% are interested homeowners, with 2% as other category. So it looks like this class is going to be very heavy on participation by board members. So that's awesome. Welcome to all of you. We don't stay on if you're a manager or you're an interested homeowner, because we have a lot of great information to help you as well. Okay, we're going to switch gears and talk about what happened in the Arizona legislature this year. A really interesting legislative year this year, I would say. From my perspective, we had a lot of bills pertaining to associations. It was kind of like the first recovery year, I would say, after COVID, where we saw a large number of bills pertaining to associations, and larger than we've seen since 2021 and 22. It was also the longest legislative session in history since I've been following the legislature for 27 years with HOAs. So longest seasonal legislature session that I've seen so far, which is kind of interesting. And, we ended up with 5 bills this year that pertain to condominiums and planned communities. So I'm just going to spend a little bit of time going over what these bills mean for our industry, who they specifically apply to, how they affect your association. And a reminder, all of these bills are the law now. They all went into effect on October 30th. So we are subject to all these laws that we're going to be talking about today. Okay, so let's talk a little bit about the first bill. And some of these bills apply only to condos, and some of them apply only to planned communities, which are like HOAs. And then some of them apply to both HOAs and condos. So I'll be clarifying at the beginning of each bill which bill applies to each category of association. So the first bill is a condominium bill. It applies only to condominiums. It was House Bill 2251, and it addresses insurance issues in a condominium. So basically, this bill is going to have some special requirements about what type of insurance condominiums need to carry. And also, it's very specific that you need to rely on your association's documents in terms of what the requirements are for insurance. It also gives the owner the right to report a loss under the association's property insurance policy, which is kind of weird because the policy is in the name of the association. And typically in the past, the only entity that could make a claim on the association's insurance would be the association's board of directors. But now the law was amended this year so that owners can report a loss under the association's property insurance policy. We haven't seen any issues of this yet in the past few weeks since this new law has gone into effect. But I don't think it's going to be that big of a difference, frankly, because first, the process is that the owner is going to need to ask the board to make a claim under the association's policy. And then if the board doesn't take action or doesn't make a claim, then the individual owner would have the right to go directly to the insurance company. Another reason why I don't think this is that big of a deal, honestly, is because remember that the association's insurance in a condominium is typically the primary insurance. And typically the owners have it's usually a bare walls policy. And the owners have their own contents insurance and also kind of like renter's insurance. But then they also have like the betterments insurance, for lack of better words, like if you have upgrades to your cabinets. So really anything from the paint in or the flooring, the subflooring in is going to be the owner's responsibility under their insurance policy typically. Okay, so that first bill only applies to condominiums and it pertains to insurance. The next bill we're going to talk about only applies to planned communities. And this bill relates to regulation of roads in a planned community. And so we've seen this bill kind of evolve over the past 4 years, 5 years, 6 years. And basically what this law says is any planned community, and you have to have very specific criteria for this bill to apply to you. So first, you have to be a planned community. Second, then you have to have your CC&Rs or your declaration was recorded after January 1st, 2015. And then the third criteria is that the ownership of the roads in your community has to be dedicated to a governmental entity or the city or the county. So there's like a lot of things that have to happen for this bill to apply to you. So remember, you have to be a planned community. Your CC&Rs would have to be recorded after January 1st, 2015. Any roadway in which the ownership has been dedicated or transferred to the city, town, or county, usually that's just set up right at the inception of the association. So if you meet those three criteria as a planned community, you need to have a meeting of the membership to determine whether or not to continue to regulate public roadways. And that meeting of the membership needs to take place within a certain time period in the next few years. And I would encourage you to take a look at our cheat sheet for more information on that if you are a planned community that falls under one of those categories that we talked about, or all of those categories that we talked about. Kind of the key thing here is it's been a big question mark whether or not if the roads are owned and regulated by the city, town, municipality, or county, and the association still enforce parking on the streets. That's basically what this bill is about, or speeding on the streets. But it's kind of a big question mark because the CC&Rs are a contract between the owners and the association. So really, if our CC&Rs say no parking on the street, we only have the contract with the owners and the owner's guests through the relationship between the owner and the guest. And so it's been kind of a big question mark over the years. So what the legislature is doing with this bill is kind of putting it to a vote of the membership. Like, hey, if you still want to have the association regulating parking and any other things like parking RVs, parking boats, parking vehicles overnight or during the day on these municipality, city, or county-owned streets, you have to vote. If you don't have this vote within the time period, you'll lose that right to enforce it. The practical reality of this bill, based upon 25 years plus of practicing law in this area, is that we can't even get a vote of the membership to return money to the owners. Think about that. So trying to get them to vote to keep control of the public roadways so that we can control parking, it's probably not going to be something that happens. So a lot of what the practical reality of this bill is that even if many associations make the effort to have the vote, it likely is not going to pass because I don't think you're going to have the requisite number of homeowners that you need to approve it because people just won't participate. Just something to think about if you live in a community with public roadways and you're a planned community or HOA and your CC&Rs are recorded after January 1st, 2015, the association likely is going to be losing their ability to enforce parking on your streets because of the strict regulations that you need to follow to under this new law. Okay, let's talk a little bit about the third bill, House Bill 2301. This one applies to both condominiums and to planned communities, and it's one of these political activity bills. Really, since 2020, the COVID legislature, and maybe even a little bit before then, I would say, maybe the elections that we've seen after 2016, we've seen a lot of political bills that pertain to HOAs and condominiums. So this bill, of course, like I said, applies to both HOAs and condos. This is like a very, very specific bill, though. This bill is going to, so if you have an association where you have it as a guard-gated community or a controlled gate community where you have to have a code to get in. So there's a fence around the association and you can't just walk in on the streets. If you are one of those associations, the association can require that if you're entering the property to engage in some sort of political activity. It could be asking for signatures on a political initiative. It could be campaigning. It could be wanting to come and talk to your residents about some sort of a proposition. So if you live in a gated community or a community where there's 24-hour guard, no one can enter the community unless they are accompanied by a unit owner or resident of the association to engage in these political activities. So it kind of makes sense. Obviously, if it's a gated community, you can't enter the property just at will. You'd have to have some permission to get in. But even if you are able to enter, you have to be with a resident of the association or an owner in the association to engage in these political activities in the community. Again, I don't really see this being something that becomes a big deal. I don't think we're going to get a lot of questions on this, but you just need to be aware of it. If you have people, we see this typically right around election times. And if you have somebody who illegally is entering your community to hand out flyers or to try to get signatures for a political initiative, unless they're with a resident or an owner, they are not allowed to be there. Okay, next bill applies to planned communities and condominiums. It's House Bill 2607, and it deals with board member removal process. Just kind of a backup on this, there's a specific law in Arizona on how you can remove a board member or board members or the entire board from office. And state law in planned communities and condominiums, the Condominium Act and the Planned Communities Act trumps whatever is in your bylaws regarding the board removal process. So it's really important that you're aware of that. What we've seen over the years is the board removal statute's been around for, 15 years. We continue to see some fine tuning and tweaking on it to address issues that may come up and may be raised to the legislature that the legislature feels a need to act on. So basically, one of the changes in this year's legislative session is that the bill adds a deadline to the board to act upon receipt of a petition that calls for removal of a member. Basically, if all the requirements for removal of a member of the board are met, so there has to be a petition signed by the requisite number of owners submitted to the board. That's kind of what triggers the board removal process. If the board fails to call, notice, and hold the special meeting to remove the director or directors or the entire board within 30 days after receipt of that petition, the members of the board are deemed removed automatically from office effective at midnight of the 31st day. So there's like a deadline with teeth now. If you get a petition as a board to remove a director, multiple directors, or the entire board, you need to act promptly. Because under this law, if you don't call, notice, and hold a special meeting of your membership to vote on the removal of these person or persons, the entire board will be removed from office effective at midnight of the 31st day. Get the removal petition from an owner or owners. You need to immediately get on the phone with your attorney and start mapping out your attorney and your management company to start mapping out, okay, how are we going to conduct this meeting? When is it going to occur? We've got to get the notice out. We need to, validate the signatures, make sure that the people that sign the petition are owners. It's a very short timeline. You want to make sure that you're meeting that, or the practical reality is the entire board is removed, even if you weren't listed as somebody that was on the petition to be removed. Okay, the last bill we're going to talk about is Senate Bill 1049, and this deals with protected flags. Over the past 25 years, we've seen a lot of flag bills and associations. So this applies to, like I said, condominiums and planned communities. Over the years, we've seen the legislature tell us that the American flag, the POW/MIA flag, the Arizona state flag, the Gadsden flag, first responder flags, Indian Nations flags, all of these flags are protected flags and must be allowed at the armed services flags. So, all of the different branches of Army, Navy, Air Force, Marines, all of these flags are protected. And an HOA or condominium cannot tell you cannot fly these flags. This year, they added another flag to that list of no banning flag rules. So this bill would make it so that an association cannot ban any historic version of the American flag, such as the Betsy Ross flag. It extends it even further. Owners should be allowed to fly the American flag, but they also can fly the Betsy Ross flag if they choose to, and that would be like the historic version of the American flag. You can find our firm's updated summary of all these bills, these 5 bills, on our webpage at mulcahylawfirm.com if you want to do a deep dive on any of these bills, or feel free to give us a call if you have any questions pertaining how these bills may apply to your association. Okay, let's shift gears and talk about our main topic for today's discussion. We're going to be talking about how to be a successful association and then how to be an A+ board member. I think over the years, I've seen a lot of different boards come and go. It's the nature of our industry. Every year there's elections in HOAs and condominiums in Arizona, and sometimes the existing board stays on, but most time we get a couple of new board members every year. And so I've seen a lot of different demographics of board members and changes in age groups. We've seen older retired demographics. We've seen younger families demographics on the board. I've seen different management companies, how they lead and how they work with associations. What I would like to share with you is, okay, here are our secrets. Here's what we think are the secret formula or the secret formula for associations to be successful. The associations that do these things seem to have the fewest number of problems. And if you don't have a lot of problems diverting your attention away from your association, you seem to get a lot of things done. And your owners are happy when the property is maintained and there's not a bunch of fighting and that Channel 3 news crew isn't at your pool doing interviews about something crazy that happened in your association. So here's our suggestions on how to have a successful board. First thing first is communication. The boards that are the most successful, they communicate all the time with everybody. It could be they're communicating with their owners, with their vendors, with the community. If your association's doing something, getting the word out about, something that's going on in your community. I cannot undervalue the importance of outstanding communication for your association. So it's probably the most important aspect of running your association. So here's some suggestions on how you can have good communication in your association. First things first, communicate with your owners all the time, whether you have a website or you're mailing, publishing, posting notice of things going on in your community. Probably the most important things is letting people know about when your board meetings are, so that if they're interested, they can attend and ask questions or become informed about what's going on at the association. Also, having an avenue for owners to go back and listen to a board meeting after the board meetings occurred. After the pandemic, I would say probably 80 to 90% of our clients are doing all of their board meetings now on Zoom. And there's a recording function on Zoom. If you're recording your board meetings, having them accessible to the owners on your website for your association. So if somebody's interested in a topic, they can go back and listen to the meeting. Of course, the meeting minutes are the official record of the association. So what happened at the board meeting? So having those board meeting minutes handy on your association's website so people can go in and do a quick 2-minute read of what happened at the board meeting. Also a very effective communication tool. Also another thing, having your financial statements and financial information about what's going on in terms of how much money the association has, how much money you have in your reserve account, what's the percentage of delinquencies, how much are your expenses? Are you on budget? Are you over budget for 2023? Having all that information at the owner's fingertips for free on the website is just really valuable because it shows that you're being transparent. And some owners like the deep dive. They want to go in and look through all that. Most owners won't, but you're going to be satisfying the needs of somebody who wants that information. Some other important things to do would be having a regular communication with the owners about what's going on in your community. Maybe you're engaging in a repainting process or a re-roofing, or maybe there's going to be like a Friendsgiving at the association's clubhouse for Thanksgiving next week. Maybe you're seeking input on converting turf into desert landscaping and you want to get people's feedback. Just constantly having an avenue to get the word out about things going on in your association and giving owners an opportunity to respond back is really important part of having a successful association because owners feel like they're informed and part of the process. It also shuts down board removal petition. I'm going to be perfectly honest with you, serving on the board, you're never going to be able to please everybody. But if you're communicating regularly to your owners, they're already informed of what's going on. And they know that if they have a question or a problem on something, they can go to a board meeting or they can reach out to the manager and get a quick question or reach out to a board member and get a quick question answered. So when that disgruntled person starts going around the pool on Sunday afternoon with a clipboard saying how unhappy they are with how things are going at the association, if you've done all this communication, if you put the time in on the communication, guess what? People are going to say, yeah, no, I'm not going to sign that because I think things are running really well, or I don't want to get involved or whatever. But if you're an association on the flip side where maintenance is looking horrible and you're about to levy a special assessment, you're not telling people why they have to pay $2,500 before Christmas, people are going to be upset. And that clipboard going around the pool is going to be getting a lot of signatures. So keep that in mind. Even though it takes effort to communicate with your owners and to constantly be updating them about what's going on in your association, it's saving you a lot of headaches in terms of problems in your community. Another point on that is if you are having a homeowner forum at the beginning of your board meeting, make sure that you're giving owners an opportunity to talk at your board meeting during that homeowner forum. So if anybody shows up and has a question or wants to give you feedback on something, that you're not shutting them out of the board meeting process. Typically, when the board goes into the board meeting, we're not seeking owner input after the board meeting starts unless the board is voting on something. Under the law, if the board is taking formal action on something during the discussion period, if an owner wants to contribute on that, they're allowed to contribute. But other than that, they're usually not involved in the meeting. So giving homeowners an opportunity at the beginning of the meeting to talk during a homeowner forum is really helpful. Then they don't have to sit through the entire meeting if they don't want to, and they can quickly, in 30 seconds or 1 minute, give you feedback on whatever they came to the meeting to discuss. Another good suggestion, conduct town hall meetings of your association, maybe once a year or once every 2 years, to get the pulse of your community, or if there's a problem, to talk about it and listen and hear feedback from your owners if they're upset about something. I've seen a lot of associations have town hall meetings recently over pickleball, over a board removal petition, which actually is a really great strategy if that happens to your community. Getting the board out in front of the community in a town hall setting to find out what people are upset about and to do better is a really good strategy. So having a town hall meeting where owners can come and their grievances or tell you how they feel about a certain topic. Another really great idea is planning some fun holiday activities or activities throughout the year where board members can interact and talk in a social environment with the owners, and also to get owners enjoying our amenities in our community. I know the association where I live, we do a really fun Easter egg hunt. We do a Christmas party. We do holiday decorating contests with prizes that are given for the best decorated homes. And so these are all, we do coffee and donuts at least once a quarter where the board pays for coffee and donuts on a Saturday morning, and people come down with their dogs and are enjoying getting to know their neighbors and enjoying the beautiful property. And having some social events also builds community and allows good communication to flow between all different parties here, the board, homeowners, homeowner to homeowner, maybe even have your manager comes to introduce the manager so they get to know that person and, would feel comfortable reaching out to them in the event of a problem. Another thing that's really important on communication, I go to a lot of annual meetings, and usually when I'm in the back of the room counting the ballots, there's a homeowner forum where homeowners talk about things they're upset about. Probably the most common complaint that I hear about boards is that the owner contacts the management company and nobody calls them back. Or the board promises something and then doesn't do it. Or the manager says, I'll take care of getting that fixed, and then it doesn't happen for 3 months. And so making sure that the association is responding to member inquiries or members' questions or members' maintenance requests or maintenance requests regarding the common areas in a timely fashion is really important to have a successful community. So getting things done, right? When issues are presented, handling them, and then letting the person know who complained about it, that's been handled. And seeing that as a positive, because if I'm out walking my dog and I see that 3 lights are out and it's making the area really dark, that's a safety hazard. And we're thankful that the owner is bringing that to our attention. We get it fixed right away. So responding to member inquiries or suggestions in a timely manner is really important to have a successful community. Another thing for good communication, make sure owners and residents know how to get a hold of key personnel at the association. So all of that should be listed on your association's website. So it'll be like the name and contact information for the property manager, the emergency number if there's an emergency that occurs pertaining to the association, or the police department's number, or ambulance and fire. All of that should be listed on your association's website. Another thing that it's hard to do, but it's a really great way to open up lines of communication is conduct a survey. The board puts out a survey. It's free. You can use SurveyMonkey or any other platform and ask members how they feel about things. Like, do you think the tennis court should be converted to pickleball? I'm sure that's going to raise a lot of controversy. So, or do you think that we should have a dog run in our community? Or do you like the turf? Should we convert it to desert landscaping? Or should we heat the pool in the winter months? Putting information out in a survey and asking for feedback is a really important way for you to understand how your constituents feel about an issue. And remember, even though you're a volunteer board member, you're elected to represent the majority will of the community. You're not, elected to the board to represent yourself. You're representing what's going to be in the best interest of the community. So conducting surveys to get feedback from the owners on important issues is a really good idea so that you're representing what the owners want in your community. Publishing newsletters, you can do that by email now at very little cost. Maybe even having a regular schedule of newsletters that goes out quarterly or maybe even monthly if you're the type of association that has enough information to put into a monthly newsletter. Just a great way to communicate with your residents and let them know what's going on, and also to let them know about anything that's going to be happening in your community in the future. Another great way to communicate would be to have a welcome to the neighborhood committee. And when new owners move into the association, going over to introduce yourselves and giving them a small, information about the association, whether it's the documents, the rules, maybe something thoughtful like a loaf of bread or just cookies or something like that. There's probably already somebody doing that, but maybe formalizing it and then having a plan for each time somebody new moves in. And the way we know that somebody new is moving in is that there's a disclosure statement that is given to any buyers. And when the property closes escrow, we're notified that the new buyer is going to be listed as the owner. And we change our records from the old owner to the new buyer. And that would be a great time for a list each month to be given to this Welcome to the Neighborhood Committee and ask them to welcome the new members to the neighborhood. Having a website and posting all the relevant information on that, we talked about that a minute ago, really great idea. Also, associations, now we're seeing a lot of social media. So we'll see associations posting on Nextdoor, having a Facebook account for the association, maybe even an Instagram page. Remember, if you are using social media for your association, just be really careful that we are keeping a very positive message and that board members individually are not speaking on behalf of the board on social media. Remember that anything that's posted on there should be approved by at least a majority of the board. Also, another thing you can do is have a self-addressed and stamped postcard or comment card that you have in your membership office or maybe in your clubhouse where people can give you feedback via that as well. Because some residents, may not have computers, may not be on social media, giving those residents that may not be as technologically savvy a way to respond and communicate with the board is a great idea. Really, one of the most important secrets of a successful association is the importance of communication. And I think I've given you a lot of really great tips on how you can communicate with your owners. And what you'll find is if you follow even some of these, you don't have to follow all of them, you're going to see a decrease in the number of problems in your community, and it's going to make your job a lot easier as a volunteer board member. Okay, another really important quality for having a successful association is to have strong leadership. So your board is elected to run the affairs of your association, the business affairs, the political affairs, so to speak, to do long-range planning for your community, to handle maintenance issues for your community. And so leadership starts from the top. And so how can your board exhibit and show strong leadership in your community? So what would be some key qualities that we see for boards that are really strong on leadership? First thing I would say is honesty, integrity, and transparency. If you're elected to your board, you are looked to by your membership, even though you're not getting paid, as the leaders in your community. You're running the most important, basically the largest and potentially most important asset of these owners. When somebody buys a home in a community, they expect that the common areas that the association maintains are going to be working, that the pool's not going to be shut down by the county, that the roads aren't going to have big potholes in them, that the landscaping is going to be beautiful, and that the lighting in the community works properly. And they expect that they're going to have transparency on the financials. and be able to explain why we need to increase the assessment in 2024 by 6% and show them the actual numbers. Here's the budget. Here's what we spent in 2023. And here's what we estimate the cost to be in 2024 to run our association. And unfortunately, we have to do an increase to meet our expenses, and then show them the numbers. Being honest, probably the biggest thing I can tell you is I often have to say, I'm sorry to owners when there's a problem that escalates to our firm as the legal counsel for the association. So maybe there's a mistake that was made by the board or by the management company or by the landscaping company, and an owner is really upset about it. Owning it. As a board, own it. If there's a problem, own it. If we made a mistake, apologize and be nice. I go to a lot of board meetings. Like I said, I've been doing this a quarter of a century. So the boards that are nice and professional and reasonable and who are accountable when there's problems, those are the boards that are the most successful, because people can deal with that. Everybody gets it. There's going to be problems in everything, right? In any business, there's going to be mistakes. But how you handle the mistake, how you communicate the fix on the mistake, and how you hold yourself accountable and say, we're sorry, this will not happen again. This is not acceptable, and we will do better. That is going to make homeowners appreciate you, be loyal to you, and support you. So those are some really important characteristics. Whenever boards say to me, I don't want to give the records, this homeowner is making a records request and I don't want to give them all these records, that is the wrong answer. What we should be saying as a board is the law requires us to provide certain records to owners. Okay, there's certain things they can't have, like legal advice from the attorney. They can't have an opinion letter. They can't have any information pertaining to a pending lawsuit, right? But pretty much everything else is fair game. We shouldn't be trying to hide records from anybody. We're not hiding anything. If you want to review the records and you're entitled to under the law, we welcome the opportunity to provide you with anything that you're looking for. That's the attitude you should be having. Because if you're saying, no, I don't want to do that, I don't want to give them the records, it makes it look like you're hiding something and that you have, maybe you're doing something wrong. And that's not the case. Typically, what the case is usually that, hey, we're all volunteers and it takes 4 hours to put these records together, right? And it's a hassle. But recognize that somebody's upset about something. That's why they're making a records request. And if we provide them the information and answer their questions, they're going to go away and this isn't going to be a lawsuit or a big problem. And oftentimes what I'll do when I get a big records request from an owner, like 20 years of records or something, and I know the client, it's going to cost a lot of money to look for those records, and I may be involved helping as legal counsel, I pick up the phone and I talk to the owner and say, tell me what's going on. What are you looking for in these records? And typically I can take, like a 5,000 page records request, and we can, through that phone call alone, we can usually resolve the issue. Or maybe I take it down to only having to give them like 5 or 6 pages of information that's really going to help answer the question that they have, versus spending hours and hours and copying documents for them, etc. Being transparent and communicating on a records request can really go a long way. Another thing really important is having integrity as a board. As a board member, you have a fiduciary responsibility it's like a duty of care, a duty to avoid self-dealing, which means that you cannot profit in any way from your time serving on the board. So you can't be getting kickbacks. You shouldn't be having vendors doing special favors for you because you're a board member. And obviously, you shouldn't be financially benefiting in any way for your volunteer time on the board. Last but not least, be a team. Okay, so if your board is struggling and you're not successful and the board's fighting, we're going to be talking about this a little bit later in the presentation, you have to be a team when you're serving on the board. And I'm really happy to say I've served on my board for almost 14 years now, on and off. Some years have been better than others, for sure. But I can tell you that the years that weren't good in my community, and I see this in other communities, is when everybody is either fighting or everybody thinks they know what's best and can't bend a little to make things work. And usually nobody is wanting to roll up their sleeves and help. That's a problem. So how do we emphasize teamwork on a board? So I think we all can agree that there's usually one or two board members in every board that does the majority of the work. Okay, just know that straight up. That's how it works, okay? But the other board, and usually it's going to be the president and the treasurer typically are the most active board members because they have very specific roles. The other board members need to be supporting team members, okay? I have served as the treasurer of my association. I've served as president of my association. There is nothing worse when you are the president of your association and you're looking at your team asking for help. Hey, can somebody cover this meeting or can somebody meet with the landscaper? When you're already doing 20 hours of volunteer pro bono service that week and you ask maybe the other board members, hey, can you help out on this? And they say, yeah, sorry, no, I can't. It gets frustrating, right? For the leader at the top. For a board to be successful, you have to have good teamwork. And there's going to be one or two people at the top who are honestly doing a good portion of the work, a majority. But then the other supporting board members at large, or maybe the vice president and secretary who may not have as many responsibilities, when they're asking for help, be there, be supportive, see what you can do to help them, because that's what makes these teams gel. Okay. And that's what makes you be able to accomplish a lot of big goals for your community. Because if you have the one or two people at the top and they're stuck doing everything for 5 years, what's going to happen? They're going to burn out, right? And then they're going to quit. And then we have to start all over again and try to train somebody to be the new president of the association. And during that training period, you typically don't get anything done. I'm not saying it's a life sentence being a president of the board, but maybe you should do it for 5 or 6 years and then you move on. And then in that 4th or 5th year, then you start training your new person, your protege who's going to be stepping up to help in the community. Working together, thinking about what's best for the community. There'll be times as a board where you don't agree on things, but majority rules. So you have to accept that you're in the minority on the board and support the board for the majority decision. You can't go around holding a sign up in front of the community saying, I wanted a playground, but the board wouldn't let me. Okay. That's not helping anybody. What you need to do is if you lose on a vote, for example, for playground, that happened to me at an association that I lived in. What I did is I tried to find a way to reintroduce it next year with all of the concerns that the board had to vote it down. I found solutions. And then guess what? It passed the next year. Working together as a team and supporting each other and being able to delegate as the board president to others on the team and having those team members step up to help, really important to have a successful team. Okay, very briefly, we also have commitment and determination. So I'm going to be the first person that tells you this, like serving on the board is not all chocolates and roses. Okay, there are many times during your time on the board where it's upsetting. I've got mostly board members here. 75% of the board are here, on this call today. And what I can tell you is that does happen. That happens in every association where you're upset about something that's happened. Maybe there's an event. Maybe the drug enforcement agency was just at your association for 4 days straight doing a SWAT on a rento property. That's not something that we created, but we have to deal with the aftermath of the owners complaining about it. Why isn't the board doing anything? And it's frustrating. These type of issues come up all the time. When you serve on the board, this is going to cross your mind at least 5 times every year. I don't want to be on this board. I want to quit. And when's my term up? Okay. You need to know that straight up. That is how you are feeling as a board sometimes. But to balance that out, if you have a scale here, you're going to be feeling that sometimes. But the majority of the time, you're going to be feeling, I'm so happy at how nice our community looks. And I'm so happy that I was part of installing the new flagpole. And that our pool has been resurfaced and it's beautiful, and that we have 2 new pickleball courts, or whatever the things are that you're accomplishing for your association. That is going to far outweigh some of the negative feelings that you have sometimes about serving on a board. So you have to be committed to making your community better, and you have to be determined to overcome the challenges that you'll have when you're serving on the board. And there will be challenges, trust me. Next thing we're going to kind of switch into is talk a little bit about what are some qualities of an A+ board member. We've talked a little bit about on a whole, how does the board function? How can we effectively function as a board? And we've talked all about communication, being a good team member, being honest, having integrity, being transparent, being committed, having determination, communicating with your owners. Now we're going to switch and talk a little bit about how to be a good board member. A couple things that we want to share with you right now. We have a great cheat sheet on duties and responsibilities of a board member. This cheat sheet, we also have a number of classes that we have taught that the videos are on our website, where we give you, in a 3-minute read, these are the things you need to know about serving as a board member. And we go through everything from what the open meeting law is and how you need to comply with it, to the fact that you need to pay taxes as an association, state and federal taxes, that there are federal laws that you need to be aware of, in addition to state laws. And so we're going to be sharing with you a number of different cheat sheets that we think will be really helpful to you so that you can be an A+ board member. So like I said, the first one, duties and responsibilities of the board. The top 10 things you need to know about Arizona law, federal laws, and what's important about federal laws, a board member's code of conduct. If you have any board members that maybe are falling below the acceptable standard, maybe having your board adopt a board member's code of conduct to best handle any difficulties that you may be having with a board member. And so all of these different cheat sheets, I think, would be really helpful to you as you are navigating how to be a good board member. Also, don't forget, reach out to your trusted advisors for advice as a board member. Obviously, you typically need the support of the majority of the board to do this, but having your attorney, know your attorney, and be able to reach out to your attorney and ask questions, and maybe even have a boot camp where the attorney comes into your association and talks about changes in the law or important laws that you need to be aware of, and maybe talks about dysfunction, if you have some dysfunction on your board, and how we can overcome that dysfunction. These are all great cheat sheets that can help you and support you as a board member. Reach out to your lawyers, your trusted advisor, your insurance agent, your reserve specialist, your management company. All of these people are here to support you, and we're on your team to help you be successful as board members in your community. Okay, last topic we're going to talk about in our last 7 minutes before we get into our question and answer is board conflict. And so I'm going to put a little poll up on the screen. It looks like we have about 120 people here with us on Zoom. And we have about 20 joining us on Facebook Live. And our question for you today is, does your association have any infighting between board members? I hope you don't, but I'd be curious just to know. We have really good representation today. If you wouldn't mind answering yes or no, or I don't know. If you're a homeowner, you may not be aware of what's the inner workings of your board. But I'll be really curious to hear what your responses are, because there have been times on my board that I've served that there has been some fighting where people think things should be done a certain way, or they don't like the direction that the board's taking. But I'd say 80% of the times things are pretty peaceful and everybody is respectful of differing opinions, etc. Okay, so our poll results are in. I'm pleasantly surprised that only 35% of you say that there is infighting between board members. 47% say no, and 18% say I don't know. So I think there's a sprinkling of you here, 35%, that are saying, hey, yeah, our board has some infighting. So let's talk a little bit about how to handle that if you're having board conflict. And we have a great cheat sheet on this topic, dealing with difficult people. And we also have a cheat sheet on using the DISC personality to help your association get along and get things done, which we're going to be sharing with you. But I'm going to give you a quick 411 on the things you need to know. Okay, so how do we deal with conflicts during a board meeting? So let's say that you have, maybe it's a lack of respect between board members, or maybe you have just like a really difficult board member who's maybe a bully. Well, first, you need to just set the stage with meeting rules that, like name calling, interrupting, personal attacks, loud voices, yelling, screaming, people that are engaging in like scary personal space tactics, standing up and yelling and getting in your personal space. None of that is acceptable in a board meeting. You should pass rules if you have that problem in your community for board member conduct at a board meeting. The next thing, how to handle board member conflict. Let's say that during the meeting, you're fighting. It's okay to have a little bit of normal disagreement between board members. Sometimes that brings out the best decision, as long as everybody's being respectful of differing viewpoints, and as long as people can accept if they get outvoted. Majority rules. So what do we do if there's conflict during the board meeting? Well, first, make sure you give all board members an opportunity to talk. Just because the board knows that going into the meeting, like, hey, I know I've got a majority of the board that want to proceed forward with the pickleball courts or whatever the issue is, you still want to give those in the minority an opportunity to express their viewpoint and to be able to talk about an issue. And you don't want to shut them down and make them feel like they're unheard. There's a fine line here because you don't want to go overboard and have the whole meeting hijacked, but there needs to be a time period when the board's voting on something. So typically we see a motion to approve something and then a second, and then it moves forward to a discussion time period. Giving every board member at least 1 minute to talk about a topic is fair and should be allowed, especially if there is, dissent or disagreement between the board members. So giving everybody an opportunity to talk with equal time is a really good suggestion on how to limit board member conflict. Add a follow-up discussion on a topic after all board members have been given the opportunity to speak. So what I typically will see at a board meeting is there might be one or two people that are dominating the discussion. And so oftentimes during this discussion period, when the board's thinking about approving or disapproving something, one board member will start and then maybe another board member will say something. And then that first board member that started wants to respond again. And so that one board member is getting like 4-to-1 time on talking about an issue. So, and that can be a problem. Enact something that says that, okay, all board members are given an opportunity to talk once before you get a second time to talk on a topic. And that's a good strategy if you have one board member who's dominating, the discussion. Educate new board members on board processes and outstanding issues, because sometimes part of the conflict is maybe somebody's elected to the board because they're upset about something. Honestly, that's how I got on my board the second time around. I was upset about something and then somebody quit being on the board and no one else volunteered to be on the board. So guess what? I was appointed to be on the board. When I got on the board, I was upset about my issue, very upset about it, but I didn't really have all of the information on it. And so it was really helpful that the board president asked to have coffee with me and talk a little bit about the problem and give me some background information that I didn't know because I wasn't privy to the executive session meetings as a homeowner that wasn't on the board. And so having an open mind coming into the board and being willing to listen to, okay, these are the issues that we're facing and here's some background information that you may not be aware of, might give you a little different perspective on things and is helpful. So providing education and having, some mentoring on issues and board processes can be very helpful to limit conflict on your board. Using a censure. So if you have bad behavior by one or two board members on your board, get advice from your legal counsel and think about enacting a censure system where, for example, this person is out of control at the board meetings and we had to call the police. Maybe officially censure that board member and maybe bring in an off-duty police officer to help you navigate the next meeting or bring your attorney to help you navigate the next meeting. If an officer is the one that's engaging in conflict or bad behavior, remember that an officer's title can be stripped typically by the board. So if you have a majority of the board that wants to remove the treasurer from his treasurer position, the majority of the board can make that decision at an open board meeting. That board member is still a board member at large, but the title has been taken away because of bad behavior. Consider adopting the code of conduct. We shared that with you earlier in this presentation today. It's a very effective tool if you have somebody who's behaving inappropriately as a board member, and it covers everything from bad meeting behavior to talking poorly about the board on social media to spreading false information, disclosing confidential information regarding the association to owners that shouldn't be disclosed under the law. These are all great suggestions that you can have your board adopt a code of conduct, and then all board members will be bound by it if a majority of the board adopts the code of conduct. And if they violate it, then get your attorney involved. Get advice from your attorney. This is not my first rodeo, right? I've been on my board for 14 years. I've been working with associations for 25 plus years. I have seen basically every dysfunctional possible situation in a board. And I have successfully been able to help many associations change and go from dysfunction to highly functioning associations. So reach out to your trusted advisors. Consider having a boot camp with your attorney to talk through the issues. Look at this DISC cheat sheet. So the DISC is a personality test that is done, and it explains why people behave the way they do. And this is a really fascinating cheat sheet. I really encourage you to look at it. And so every team has different personalities on it. And so what we want to do is try to figure out what personality types the board members are, and then give them jobs that are going to best match with their personality. I do this typically with boot camps all the time. I ask everybody to take the personality test, and especially where there's a high level of dysfunction. And we talk about, okay, these are the personalities here at the table. Susie is a C personality type, which has a high need for detail. And so when Susie is asking the treasurer for more information about the finances, she's not doing it to harass the treasurer. She's doing it because that's how her brain works. She wants to see the bank statements. She wants to see the most recent year-to-date budget. In fact, Susie probably should be the treasurer because she's such a high detail person. Then you have people who are just good supporting members, the S personality type, where they're just really good team members and they don't like conflict. Having this person at this table with all this fighting causes that anxiety for the S personality type. Then we've got the I personality type, which gets along really well with everybody, social. We don't want to make that person the treasurer. They're not going to be successful there. What we want to make that person in charge of is the Christmas party and getting the word out about the annual meeting, communications type things. And then we've got the D personality type, which is the dominant personality type. That person is a great person to get decisions made. They help the group. Typically, in my experience, successful associations typically have the D person as the president because they don't like to have long meetings. They like to make decisions. They try to, force the C person who likes all the facts and wants to look at everything 18 different ways before they make a decision. They push that C person to make a decision, and that C person slows down the D person. And so once we go through all of these different personality types, people are usually laughing because they're like, oh my gosh, you're right. That is so true. That is why Susie is always wanting more detail from the manager. And so we explore, okay, this is how the personality types are working, the dynamics here. And this is maybe why we're struggling as a board. Maybe we need to kind of realign the positions and talk through some of these issues. And maybe you've got a bully on the board. Maybe we need to talk that through. How do we handle that? How do we curb that bullying behavior so that it's not going to ruin the dynamics of the board? So really, all of these are some good suggestions for your board if you're facing board conflict. If you don't have it right now, if you're in the 47% or 18%, if you don't know, keep this in your back pocket as something you can bring out if you get into a difficult situation in the future on your board. Okay, let's switch now to our questions. We're going to start with our first question. It looks like we have about 24 questions this morning, so great turnout. Our first question, I typically read the question and then I'll answer the question. In our CC&Rs, under application of payments, it states all payments received by the association shall be applied first to the principal amount due, including late charges and attorney's fees, and then to interest accrued. Is this recommended for HOAs? It is the opposite of the usual practice of banks and credit card companies. That is true. Actually, there's a state law in Arizona that directly addresses this as well. So if you're a condominium, it's ARS 33-1256J. If you are a planned community, it's 33-1807J. And basically what this says under Arizona law is that all payments received on a unit owner's account are applied first to any unpaid assessments, unpaid charges for late payment of those assessments, unpaid reasonable collection fees, and unpaid attorney's fees and costs incurred with respect to those assessments in that order, with any remaining amounts applied next to other unpaid fees, such as fines, charges and monetary penalties, or interest and late charges on monetary penalties. This section is going to be controlling under the law, not the section in your CC&Rs. So yes, payments should first be applied to assessments, late fees for those assessments, any collection fees that you may have charged by your management company, attorney's fees, and costs in regard to those assessments in that order. And it is unusual because you're right. Usually you pay interest on your mortgage first, or your deed of trust first. You pay this on your credit cards. You're paying interest on a monthly basis and maybe not even paying down the principal in some cases. But this is specific to Arizona law. Our legislature passed this for a reason, and they want to make sure that all payments are paid in this order. Okay, next question, number 2. Assume an impending community vote to increase association dues. What best practices should be employed in response to vitriolic misinformation and false written and verbal claims by a minority of residents strongly opposed to the proposal? Further assume the false claims include allegations of dishonesty and fraud on the part of board members. Ooh, that sounds like a difficult situation. Okay, a couple things. Increasing association dues is a necessary evil. Okay, when board members come to me and they say, we haven't raised our dues in 12 years, isn't that great? I'm thinking I have to take a deep breath, because that's not great, because everything else is getting more expensive with inflation. And so you are operating with the same dollars and everything's costing more. And what does that usually result in? Deferred maintenance, not being able to renovate common areas that need to be renovated and upgraded and improved. And so having increases is normal. In fact, every association should be having an increase, even a small increase every year. Okay, so what do you do here in the situation where you've got a group that's really upset about an increase? I think it's time for a town hall meeting. You need to get the information out, communicate to your owners why this is necessary. The best way to do that is show them the numbers. Show them what's been happening in 2022 and 2023. And that expenses are continually going up, and we can't afford our expenses unless we raise the dues. And this is the only way we can do it. So have a town hall meeting. If you think people won't be receptive to coming to a town hall meeting, start pumping out information about why this is necessary. Give owners a place to call, to ask questions, to answer, have their questions answered. You're going to have to do a PR campaign to fight this alternate universe group that is trying to undermine our ability to function as a business. Okay, next question. Are CC&Rs written in 1979 with restrictions on public street parking? CC&Rs amended in 2017 concerning an unrelated issue. Did the amendment forfeit our control over street parking? If we rewrite the CC&Rs, can we include the parking restrictions? I don't know enough about your associations. I don't know if you are an HOA. I don't know if your streets are actually dedicated to the public. It looks like they are. So it's hard for me to answer this one. And I also don't know specifically about the amendment to your document. So this one I think we're going to have to sidebar on and take a look at. We'll see if the new law applies to you or not, and if you're able to continue regulating the on-street parking in your streets. Okay, next question. So for this person, go ahead and email me directly, and send me your CC&Rs and the amendment, and I'll take a look at it for free. Okay, next question. Can an HOA require a homeowner to use a licensed contractor, for instance, in installing solar tubes on their roof? The roofs are maintained by the HOA, or replacing sunscreens. I'd like to see your CC&Rs as well on this one, but if you are maintaining the roof as an HOA, that's one of your responsibilities. I'm pretty sure that putting solar tubes on the roof could potentially void the warranty for any, roof warranty that you may have. So I do think that having a licensed contractor requiring that, it does not seem unreasonable. Remember, under the law that we can't effectively prohibit somebody from having solar energy devices on their property. So I think there's kind of a balancing factor here. I don't know what you mean by solar tubes, but I'm assuming that that's like a solar energy device that would fall under the law. And that's not something that, you should just throw that spaghetti up there on the roof and anybody can do it. Now, you need like a licensed and bonded solar company to do that. What about replacing sunscreens? That's probably, I don't know who's responsible for the windows or whatever, but that's probably going to be their responsibility. And I don't think we can force them to use a licensed contractor. However, we want it to be aesthetically pleasing, and they probably do need to seek architectural approval before they do that. You could encourage them to have somebody who's professional, licensed, and bonded be doing the work. Okay, question number 5. We recently had a special assessment for painting our units. One owner refuses to pay. Our management company says we cannot send this matter to collections unless our CC&Rs say specifically we can do this. Ours say we can collect our monthly assessments and delinquent assessments. So this owner has gotten a freebie and our management company will do nothing. Is this true and what are our options? Okay, so we have 2 cheat sheets that I think would be helpful here. One is on collecting assessments and one is on secrets to collecting assessments. I don't know. I don't have your CC&Rs, so I don't know. Do your CC&Rs not have something on the ability to levy a special assessment? I'm assuming that's what you're trying to say here. And so most of the people paid it to paint, but there's one person that hasn't. I think you really should encourage your board to escalate this to your attorney, because even if the contract doesn't, the CC&Rs is the contract, doesn't allow for you to collect this money under the terms of the contract, there's no special assessment section, we might be able to collect this under like another legal doctrine, like they've been unjustly enriched or under quantum merit. So let's take a look at this. I mean, I would at least try. It can't hurt to send a letter saying, hey, you benefited from this, you need to pay for it, and see what the owner's response is. But you should definitely escalate that to your attorney to get an opinion. I don't know how much it is, but typically painting is a couple $1,000s. So that's a lot of money to be out. Okay, next question. Hypothetical. A majority of homeowners decide to have security cameras for common areas removed. 2 months later, a crime occurs that could have been prevented if the cameras had been in place. Who may be held responsible, the association or the homeowners in question? Ooh, really good question. So we have a great cheat sheet that we're sharing with you right now on preventing crime and limiting liability for an association. This is kind of a sticky wicket question because just because the security cameras were removed, I'm not sure that there's a direct correlation that crime would have been prevented. It maybe would have been filmed, but I'm not sure it would have been prevented unless there's somebody live watching it 24/7 and they could have sent the security guard for your association there right away if they saw it. Here's what I will say is that if the homeowners, a majority of the owners are saying we don't want this anymore, and then the board responds by taking the cameras out, there could be some liability for the board, but it's going to be lowered because the homeowners don't want the cameras, right? And we're acting at the will of the homeowners. But there's a case in Arizona that I think is important. And it talks about the association's board is required to keep the common areas safe and free from crime. So if we had security cameras in place because there had been a lot of crime in your association, and then we decided to take them out, even though we knew that crime was continuing, under the Martinez versus Woodmar condominiums case, that's problematic in Arizona because we have a duty to keep the common areas safe and free from crime. And in that case, what happened was an association had a security guard that was roaming the association because there was a lot of gang activity in this association. And due to budgetary constraints, they had to get rid of the security guard. And then what happened is the guest of a tenant was shot on the common areas of the association. And the association was sued for not having the security guard anymore. And there was a lawsuit. This was a reported decision in Arizona. And the insurance company for the association likely paid out some of the damages for that particular issue. So can there be liability possibly for the association if they knew that there was an issue and they still agreed to remove the cameras because the owners wanted them removed? I mean, that turns into a situation we really want to get your attorney involved to talk about what is liability here. And is it a good idea to listen to the owners when we really have a fiduciary duty to keep these common areas safe? Can the owners who voted for this be sued? Probably not. I mean, anybody can be sued in a lawsuit, but I don't think they're going to be held liable for, signing the petition on this. Oh, and also look at the cheat sheet on preventing crime and limiting liability. We have some great suggestions for you if your association is seeing an uptick in crime. And so I'd really encourage you to take a look at that. Next question. What would you think if you're the board treasurer and someone else closed a financial account without your knowledge? What would I think? I would think I would be mad because as the treasurer, you are responsible for oversight of the finances. So you should have been consulted on that. Now, I don't know if that someone is the management company, and maybe it was in the contract that after a certain period of time, after they took over as management company, you were switching to their bank. That process probably would be okay. But if it's a board member or the management company does it without any knowledge and there's no justification or basis for it, I'd be taking a second look at it and asking for why this happened and make sure that their expectations set for the future so it doesn't happen again. Sometimes they're like a CD's up for renewal, right? And we're just going to throw it right into another CD at the same rate. I mean, I wouldn't be upset about that because they're helping your association. So if it's something like that, then I would not be upset about it. But I would ask for more information and ask for their feedback before you get upset, so you hear their side of the story. Okay, what does an HOA do when no one wants to serve on the board? I had this question twice last week, actually. A couple of things. Pump out information asking for people to be on the board. Okay, so send out letters, newsletters, please asking people to volunteer. If that doesn't work, try to pinpoint specific people, maybe that have come to the board on issues and have been reasonable. Pick up the phone, call them multiple times, see if they will volunteer. If that doesn't work, look to your committees. Do any committee members willing to step up and serve on the board? If that doesn't work, then reach out to our firm. We have a letter that we send to the owners, letting them know that no one's willing to be on the board. The next step will be to have the court appoint a receiver to run the affairs of the association. This will be very expensive, at least $80,000 in receivership fees annually, and that will be passed on to all the homeowners in the form of a special assessment or an increase in the monthly assessment. I cannot think of one time that our firm has sent that letter where we didn't get a board member or board members to start running the board. So it's a very effective solution to get people to step up and help. Next question. What does an HOA do? What can a homeowner do if the association board fails to respond to a violation appeal within 10 days as allowed by the state statute? I don't know specifically which statute you're referring to, but I'm guessing that you were sent a violation letter by your board, or somebody you know was sent a violation letter by your board, and then that person who received the violation letter wrote back to the board with a certified letter requesting certain information. And that's what triggers under Arizona law for the board to respond back with the information that's required to respond back to under the law, such as who witnessed the violation, what section in the CC&Rs was violated, what are the potential penalties or repercussions of this violation, and what actions can the board take. And so if they didn't respond after that, what can you do? You can send a letter back saying, hey, cite the section in the statute that says, hey, you were supposed to respond to me and you didn't. Please respond. If they don't respond after that, you can file a lawsuit. You can go to the ADRE and file a complaint there. Arizona Department of Real Estate. There's a administrative law judge section that handles homeowner and association complaints. That's an option. One thing you want to think about, though, is that lots of times the initial violation letter already complied with that law, and that may be why the board is not responding. So maybe that initial letter already had all that information in there. If you're a board listening, we've got 75% of you here today are boards. If they send this certified letter, go ahead and send it again, the information, because you don't want to get into a fight about what the statute says. Or you could send a letter saying, we received your certified letter asking for this information. It was already provided in the initial demand letter. If you have any questions, please reach out to us to let us know. Try to resolve this amicably. This is not something that needs to turn into World War III. Okay, next question. After our annual meeting, our CC&Rs say we have to have a meeting to elect officers after the election at the annual. Does this need to be noticed as the meeting? Best practices would be to have in the annual meeting notice an indication that after the annual meeting is over, there will be a quick open board meeting to elect officers, or you can have a separate meeting after the annual meeting and do it quickly after the annual meeting. Notice it 48 hours in advance of the meeting. Just state that the purpose of this meeting is going to be to elect officers for the 2023-24 year. But yes, it does need to be noticed, properly noticed, to be perfectly, legal under the open meeting law. Okay, question number 11, ratification of board unanimous email voting. What is the procedure to get board email voting ratified at an open board meeting? Okay, let's back up a little bit. I am not, as an attorney that practices in this area, I am not in favor of boards taking action by unanimous written consent. There are at least 2 administrative law cases in Arizona that say that this violates the open meeting law. So be really careful on relying on the Nonprofit Corporation Act to make decisions as a board by unanimous written consent. I think if challenged, it's not going to withstand a legal challenge based upon what the open meeting law says, saying that, any decision that anytime a majority of quorum of the board is meeting to discuss association business, it needs to be an open board meeting. This directly contradicts that. Having a meeting outside or making a decision outside of a board meeting by email to get around having an open board meeting, it's properly noticed. I think that violates open meeting law. Even though the Nonprofit Corporation Act allows it, and most of our clients are nonprofit corporations, the open meeting law is more specific and trumps it. And there's 2 cases in Arizona by administrative law judges that support what I'm saying. When can you use email as a board to make decisions? In an emergency situation. The 48 hours notice is suspended under the open meeting law, and you can make decisions by email in a true emergency situation where you cannot wait 48 hours to make the decision. How do you ratify that decision after the emergency board meeting or the emergency board email vote? At the very next open board meeting, you read into the record what happened, what you did, and what was decided. And that is sufficient. If you have an emergency board meeting and you don't give the 48 hours notice, you should take minutes so that there's a reflection on that. If you're making decisions by email, you should keep those emails and then add all of those, either the emails or the minutes of the emergency board meeting, to the attachments for the minutes of the meeting where it's ratified. Next question. We have a great cheat sheet on open meeting law too, which our office has shared with you in the Zoom chat and then also on Facebook Live. Okay, next question. Regarding street regulation, can the special meeting the law requires for voting be as part of our annual meeting with a separate mail-out ballot? And is the quorum required the 1/10 as mentioned in our bylaws? Or is it a simple majority of our members? So yes, you can have that vote as part of the annual meeting. No problem. You can use a separate mail-in ballot. You could even attach it on the main ballot. I'm going to need to have my office pull that statute just so I can look at the specifics on what the majority vote is. And then I'll come back to this question at the end. So that's going to be the new statute that was just passed. I'm going to need the actual statute language, not the summary that we did at the beginning of the class. Okay, and you should be able to find that in the Planned Communities Act very quickly for my team that's looking for it. Question number 13. In a planned community that has private streets, does the Disability Act regarding parking and obstructing sidewalks apply? So yes, in a planned community, the Fair Housing Act would apply. The Americans with Disabilities Act typically does not apply because associations are typically not a place of public accommodation, but the Fair Housing Act does apply to associations. And so if an owner or a resident is parking in such a way that makes it difficult for handicapped residents to access the mailbox or to be able to use the sidewalks, that could be considered a fair housing violation by the association, and the association needs to take action to make sure that that's not happening. Next question, number 14, jumping back to the new parking law. Are private roads in a gated community exempt from this new change? Yes. Number 15, regarding protected flags. Is flying a U.S. flag upside down protected? I think that's a violation of the federal flag code and it would not be protected, but I would encourage you to just Google federal flag code, and I'm pretty sure it has to be flown in the proper manner. It has to be illuminated at night. So flying it upside down, I don't think is going to be allowed under Arizona law, because our law says you have to comply with the federal flag code when you're flying the American flag. Okay, question number 16. Under the new law, does this mean, and this is the removal law, does this mean if one member is on a petition to be recalled and the board fails to call, notice, and conduct the removal meeting within 30 days, all board members are removed, or only the name on the recall petition? Under the language of the statutes, it's all board members would be removed if they failed to comply with the new sections in the removal statute in the Condominium Act and the Planned Communities Act. Okay, next question. Is any time or way the board meets subject to the open meeting law? Some boards have catch-up coffee times, agenda setting conversations, informal gatherings. Are all of these subject to the open meeting law, such as providing 48 hours notice in advance of the meeting? Also, what are the notice requirements, if any, should the board members gather for holiday events and these events are clearly social? Okay, so again, we're going to be sharing with you our cheat sheet on the open meeting law because this does a deep dive on everything you need to know about the open meeting law in Arizona for board members. But the bottom line is here. Anytime a majority of the board or a quorum of the board is meeting to discuss association business, it's subject to the open meeting law, which means that you have to provide notice to the membership 48 hours in advance of the meeting and allow members to attend, listen, and participate if they choose. So is there any way around this? A workaround would be have less than a quorum of the board meeting to have coffee time, agenda setting conversations, informal gatherings. So if you have less than a quorum, it's not a board meeting. If you're having a social event, it's not a board meeting. If you're having a social event and a quorum of the board is discussing association business, you just crossed over into meeting. So if you're at a social event, do not discuss association business, okay? Only meetings are the only time that you should be discussing association business with the quorum of the board. Question number 18, looks like we have a couple more questions that have been answered. So we have 28 questions now. In an HOA gated community with a restriction on street parking after 11 p.m., is it legally permissible for the community to allow parking after 11 p.m., specifically for holidays without violating the Fair Housing Act? Or would they be required to extend this privilege to all holidays uniformly? A couple of things here. So if your HOA it's gated, so this new law that we talked about earlier does not apply. If your association is gated and you have an on-street parking, no parking after 11 p.m., you really shouldn't be allowing parking after 11 p.m. If it's worded, no parking shall be allowed on the streets after 11 p.m. Okay. It doesn't matter if it's a holiday. I mean, of course you can be flexible. Sometimes there are days of the year where you might be having a party or something for a holiday. You can be flexible, but you don't have to be if you don't want to be as a board. I would err on the side of, not picketing people on Christmas Eve or Christmas Day, but they shouldn't be doing overnight parking, obviously, on the holidays. Is this a violation of the Fair Housing Act? No, the Fair Housing Act doesn't extend. There's no protection for holidays under the Fair Housing Act that would allow you to violate the on-street parking rule. That's not going to apply here. Okay, next question, 19. What evidence would be necessary to appeal to the state for violation of the open meeting law? What action could be taken by the state to require condo directors to comply with the open meeting law? Okay, a couple places where you can go. You can file a lawsuit in Superior Court asking for a mandatory permanent injunction, compelling the board to comply with the open meeting law. That's one option. There's going to be some costs to do that because lawsuits can be expensive. But one avenue would be to file a lawsuit in Superior Court asking for an injunction, compelling the board to comply. Another avenue, go to the Arizona Department of Real Estate website. Our office is sharing the link with you in the Zoom chat and also on Facebook Live. And basically, you fill out the paperwork with the Arizona Department of Real Estate for a complaint against the association. You have to pay a $500 filing fee, and they will assign this complaint to an administrative law judge, and there will be a hearing to decide whether or not there's been a violation of the open meeting law. The administrative law judge is just going to say whether there has been a violation or hasn't. Okay, and then the board would have to pay the filing fee, the $500 filing fee, if it's found that they violated the open meeting law. But it doesn't make them comply going forward. It just says, yes, there was a violation. They did not comply with it. The only way you can make them to comply going forward is to go the Superior Court route and get an injunction compelling them to do that. Question number 20. Is there a legal requirement that board members enable their cameras during a video board meeting? How do members verify that the board members are present if their cameras and video is disabled or shut off and motions and seconds are conducted properly? I'm kind of laughing about this because I'm kind of a violator on this sometimes on my board meeting. you're allowed to appear telephonically at a board meeting. Okay, I don't do it often, but like, let's say our board meeting's running late at 6:30 at night and I got to pick up one of my kids at lacrosse. Sometimes I'll say, hey guys, I need to go get one of my kids. I'm going to stay on the call on my phone, but I may need to go to telephone only because it's dark in the car. I think as long as you're communicating why the reason is that you have the camera off, I think that's fine. It's best, of course, to have the camera on so everybody can see the board members. But I don't think there is a legal requirement that you have to have your cameras on because state law allows board members to appear telephonically at board meetings and you don't have to have the camera. We also have a great cheat sheet on virtual meetings, which kind of covers some ins and outs of how to conduct virtual meetings that we're going to be sharing with you in the chat and on Facebook Live. Question 21, are HOA boards required to follow Robert's Rules of Order? We have received conflicting information on this. So unless your board bylaws require you or your CC&Rs require you to follow Robert's Rules of Order, you do not have to follow Robert's Rules of Order. It's very unusual that I'll see that in the bylaws, and whenever I see it, I take it out anytime we're doing an amendment because Robert's Rules of Order is extensive and there's lots of ways you can violate it just by not reading the 12 volumes of parliamentary procedure to follow that. So we've got a great cheat sheet on board meetings. And in that cheat sheet we're sharing with you now, we talk a little bit about what parts of Robert's Rules of Order or parliamentary procedure you should adopt because they're just good business practices. So I'd encourage you to take a look at that. Question number 22. If an association's articles allow a variable number of directors, odd numbers like from 3 to 7, what board process should a board take to change the current number? Well, first look at what your bylaws say, because it may say something like your board can be like anywhere between 3 and 7 board members. And, the way to change it is this. So make sure that the procedure isn't outlined in your bylaws. Most of the time it's not. So what you want to do is talk with your attorney and figure out how we're going to implement this. So, maybe you notice that you're going to do this at a regularly scheduled board meeting. You vote to increase the board. And then maybe at the next annual meeting, those 2 spots are open, and then they're elected, or maybe you're just appointing to fill those vacancies. So it's typically done if it's not outlined in your bylaws how to do it at a board meeting, and you should talk to your legal counsel about the best way to do it based upon your documents. Okay, question 23. I am a very active homeowner and know most of the other homeowners. Our board believes that electronic communication is sufficient. How can I convince them that many of our residents do want communication via paper and don't like electronic communication? We also have many full-time tenants that do not have access to the website, but who want to be involved, but they don't know about events. We have a close-knit community, but word of mouth is not always enough. People want the reminder on the fridge. Okay, great question. So this is kind of like a push and a pull between technology and paper, right? I think probably the best way to get the message to your board would be just start a little petition and have people sign it saying that in addition to the online or electronic communications, we also would really like to have paper communications. Now, this may be a cost thing. So, maybe the board doesn't want to pay the cost to mail things every week to people. Maybe if this is something that a lot of owners in your community want, maybe there can be a stack of papers in a central location at your association where anybody who wants the paper can go to the mailbox and pick it up. Or maybe because you are very active and know a lot of homeowners, maybe you could offer to get the word out to people by handing it to them. I'm sure there's some sort of a resolution that can be reached here once the board understands that, okay, this many owners really want this. And the best way to do that would be to have a petition or a survey done by the owners and then take that information to the board. Okay, next question, number 24. When talking about a censure, what actual effect does a censure have? Good question, picking up on that. It's a written documentation that this person is falling below the standard expected of a director in the community. And it's in the minutes. It could be used as evidence in the future if there's going to be a petition circulated to remove this director from office. It could be evidence that's used in a court of law if there's a lawsuit regarding behavior of the board member. But really, a censure alone doesn't do much. You're right. It's not like that ejects them from meetings or anything like that. No, it's just a written documentation that sets the stage to be used at some other time in the future. And it also puts the person on notice. Hey, your behavior is unacceptable. We are documenting it in the meeting minutes, and we are keeping a paper trail now so that this behavior is documented so it doesn't continue. Question number 25, open meeting law's intent seems to be to ensure that boards are not having discussions and making decisions behind closed doors, like email. This normally limits boards to only discussing topics with a quorum in the board meetings. What could a board do to have discussions as a quorum outside of board meetings, like a public boardroom, Facebook page that's accessible to everyone, or just don't? I would probably say just don't. If a quorum of the board is meeting, it really needs to be noticed and an open board meeting. If you less than a quorum can meet to discuss association business, but not a quorum unless you follow the open meeting law. Some of our clients have what they call like board planning meetings, and no decisions are made at these meetings. So basically it's the board puts out notice, hey, we're having a planning meeting, and it's a quorum of the board is going to be there. So we're giving you 48 hours notice. It's only going to be the board talking because there's no formal action going to be taken by the board. And we're just discussing issues. That way the board doesn't get interrupted by the homeowners. Some boards like that, but be really careful. You do have to comply with the open meeting law. And that is probably one of the most prevalent things that associations get sued for. It's usually not the only thing, but it's an add-on that, hey, and also they don't follow the open meeting law. And here's the proof. Okay, next question. Shall a management company make all accounting visible to the board treasurer? 100% yes. Number 27 out of 29 questions, because I'm going to return to that other question. Okay, our CC&Rs say that the board can acquire and convey real property except as that described as common elements under Arizona law 33-1212. Does this give the board authority to purchase property on behalf of the association? First, you got to look at your CC&Rs, which it looks like you've done. And it says that the board can acquire, meaning buy, or convey, sell property, except that as described as common elements. I guess yes, but this is kind of complicated because it sounds like you're a condominium. So you can't obviously sell your common elements because each owner owns a percentage interest in the common elements in a condominium. So can you buy property? I don't know what you would be buying property for. Maybe the adjacent property is, like a vacant lot and you want to put pickleball or shuffleboard or tennis courts in there. I would say you definitely want to look at what your documents say. We want to look at what Arizona law says, and you want to get your attorney involved because you also want to know, hey, can we use our assessments for this purpose to buy it? So you may have the authority. It looks like you have the authority to buy land, but hey, can we use assessment money to buy the land? It may not allow you under the language of the CC&Rs to do that. So this is a complicated legal issue. You definitely want to get your attorney involved because you're going to need to integrate that property into the plat for your association. You're going to want to find a way to finance it, pay for it. And there's a lot of legal issues on this that you're going to need to run by your attorney. Okay, next question, number 28. We recently had our annual meeting and voted on an important issue. Some board members canceled important information from the membership. Is this legal? And if so, what action can be taken? This is kind of hard because I don't know what was canceled and I don't know what the important issue was. So it's hard for me to comment on it. I have to expect that there was a reason. Maybe there was too much information and we only focused on the most important information that evening at the annual meeting or that afternoon at the annual meeting. I don't know. If you were withholding information from the membership intentionally to get the vote, that I would not agree with. So you want to, like I said, transparency is very important when you're serving on your boards, that you build trust with your owners. And when you try to hide something or you give half information or half truths, it's going to come back to bite you and it's going to make a very dysfunctional association. Question number 29. should the management company make all financial information available to all board members other than the treasurer or just the treasurer? So I'm a proponent of everybody getting everything. So in my association, we in our board packet every month, we get everything. We get a copy of the bank statements. We get the year-to-date budget. We get the financial statement. We get copies that the CDs are in existence and when they need to be renewed. We get everything. And I think that's smart because you may have a treasurer that's not that financially savvy or doesn't have a lot of financial experience. And so everybody on the board is accountable to make sure that everything's in order. The treasurer has a higher, heightened level of accountability, but the whole board is responsible for this. So, and this comes up from time to time. When we see embezzlement in an association, it's typically when the board is in the dark and they don't know what's going on the finances. So be proactive. Ask the management company to provide this. They should have no problem providing this to you. One thing I want to warn you about is there's a delay usually. Like we always review last month's financials at this month's meeting. Okay, so you're not going to have everything real time, typically. Sometimes there's a delay. Okay, now I'm returning to this question. This is the last question for today. This is on the new legislation. To reread the question regarding street regulation, can the special meeting the law requires for voting be a part of our annual meeting? I said, yes, it can. And is the quorum required 1/10, as mentioned in our bylaws for the meeting where we vote on this parking restriction or the roads being able to maintain or keep regulation of roads in our planned community? Or do we follow the quorum requirement in the bylaws, or is there a special quorum requirement under? Okay, so the statute number is 33-1818. And basically, again, just to refresh, because we got a lot of questions on this today. So if you're a planned community and the declaration was recorded after December 31st, 2024, so there's a couple different ways that this law is written. So I think we need to back it out. So if you're a planned community, right, and the streets are owned by the city, town, municipality, or county, and your declaration is recorded after December 31st, 2014, and after the period of declarant control, the association cannot regulate any roadway for which the ownership has been dedicated to or is otherwise held by the governmental entity. Okay, so that's very important for you to hear. So if your association was, created after December 31st, 2014, and you're after the period of declarant control and the streets are owned by city, town, or municipality, the association has no authority and shall not regulate any roadway for which the ownership has been dedicated. Okay. So now we look at the new law. So after December 31st, 2014, bam, you can't do that anymore if your CC&Rs are recorded. If we go back to what the new law says, and I hope that, I think maybe I may have misstated here when I talked about it early, so I'm glad we came back to this. So now the difference is it was recorded before. If we go to the new law now that we just talked about, so again, after December 31st, 2014, you don't even need a vote anymore. This is what the law says. You cannot control parking or any sort of regulation of the roadway, okay, if the roads are owned by the city, town, or municipality. So after 2014, December 31st, 2014, can't regulate it no matter what. Before 2000, so if you have an association that's no longer under developer control, and the declaration was recorded before January 1st, 2015. And that regulates any roadway for which the ownership has been dedicated, right, to the governmental agency. Then here's what you follow. So any association before January 1st, 2015. By June 30th, 2025. So before June 30th, 2025, the planned community has to call a meeting of the membership on whether or not to continue to regulate public roadways. If the number of owners voting at the meeting on the question is sufficient to constitute a quorum of the membership, so your 1/10 is okay, and a majority of that number of votes to continue regulating the public roadways in the planned community retains its authority to regulate the public roadways. And then the board has to, if that happens, so if you have the meeting before June 30th, 2025, and you have a quorum at that meeting, which for your association looks like it's 10% according to your bylaws, and the number of members at that meeting, if And a majority of that number, a majority of the quorum, whatever it is, how many people are there? Let's say you've got 1,000 member association, and a quorum, if it's 10%, is going to be 100. And 51% of those 100 that come say that they want to retain authority to regulate those public roadways. Guess what? You can retain the public roadways. The association needs to record with the county recorder's office a document stating that they're going to continue to regulate the public roadways. If it fails, and the community either doesn't hold a vote before June 30th, 2025, or it fails at that meeting that you have, you don't get a majority of the quorum, then you no longer will be able to regulate the public roadways, and the existing regulations and the CC&Rs will expire. And again, it doesn't apply to one-way streets, and it doesn't apply to any privately owned roadways. So this is a really confusing law. So if your CC&Rs are recorded after December 31st, 2014, and your planned community, publicly owned streets, you cannot regulate on-street parking, okay? If you're one of those associations that had CC&Rs that were recorded before January 1st, 2015, and your planned community and streets are dedicated to the city, town, municipalities, counties, you have to go through this voting process, okay? And if it passes, you record it with the recorder's office. If it doesn't pass, you lose the right to enforce it. I mean, I think the writing's on the wall here, right? I already kind of said this in my presentation. The writing is on the wall that this is going to be difficult to get this vote, if not impossible. And the writing was on the wall several years ago when the first part of the law was passed, saying any CC&Rs after December 31st, 2014 that are recorded, you can't regulate anymore. So I think we know the trend here is that on city-owned streets, government entity-owned streets, county-owned streets, it's not going to be likely that HOAs are going to be able to enforce parking restrictions going forward. And I'm sorry, I think I did misspeak in my first part of the presentation. I should have said before any association where the CC&Rs were recorded before January 1st, 2015. That's when we need to take this vote. So I apologize for that. Okay, well, let's finish up here. A few things to mention. We had 119 live viewers on Zoom and many others on Facebook Live today. So thank you so much for making an effort to be here today. Don't forget, we have our December events coming up. In December, we do not, due to the holidays, have a third Tuesday in December neighborhood services HOA class with the topic like we did today. Instead, what we do is we have our first Friday. And we do that normally, as you know, the first Friday of every month at 9 a.m. We hop online and Zoom and Facebook Live, and we answer questions for free of charge. So in December, it's like a huge event because we take our normal neighborhood services HOA Academy classes and we combine it with First Fridays, and we answer a lot of questions. I think last year we had 50 plus questions. So it's going to be a great opportunity for everybody to get their questions answered for free. And that is going to be on Friday, December 1st at 9 a.m. And it's going to be our firm's virtual First Friday event and class number 12 of our virtual HOA Condo Academy. But the class is going to be limited to just answering questions that are submitted for the class. Also in this class, we're going to give you a little bonus information. We're going to provide tips for keeping communities festive and safe this holiday season. And we'll wrap up 2023 with our lengthy question and answer session where we answer every question you may have that your association may have over the past year. As you know, we teach these classes pretty frequently. We're doing it once a month, and then we have our First Fridays once a month as well. Please consider leaving our firm a Google review. It's really important that we receive feedback from you as to how we're doing, what type of classes you'd like to see, and we provide that information to the different neighborhood services departments so that they can show it to their supervisors and their city councils to let them know that the classes are needed and wanted. So I really encourage you, if you have time today, to please leave our firm a Google review so that we can then share the information with the neighborhood services departments, with the different cities around the valley, because we're starting to plan our classes for 2024. If you check out our website, we already have the first 6 months of classes listed on our upcoming classes seminars tab, and we always welcome feedback so we can improve. We're going to be sharing a link, if we haven't already, in the chat on how to leave a Google review. Again, it's really helpful for us to hear from you. We are always happy to get the feedback so we can continue to improve. Okay, last but not least, happy Thanksgiving to all of you and your families. It's certainly my pleasure to work with the different neighborhood services departments around the valley to provide this free education. I love getting the questions and hearing from all of you. And thank you so much for caring about your communities and wanting to make them better, spending time to learn. And also thank you to my entire staff, especially Morgan, Costa, and Jen for everything you do to help make these classes be successful. I appreciate you and very thankful for you. So happy Thanksgiving, everybody. I will see you again on December 1st. Take care.
Don't forget, our free cheat sheets are available for download at mulcahylawfirm.com.
The intent of our Zoom, Facebook Live, First Friday free call-in, videos, and podcast is to provide a forum for board members and community managers to receive answers to HOA and condo legal questions. Please note, the content of these sessions are general in nature and is not intended to and should not be relied upon or construed as legal opinion or legal advice regarding any specific issue or factual circumstance. You should directly consult with an attorney for advice regarding your individual situation.